The U.S. Supreme Court declines to interfere with a lower court ruling regarding access to former President Trump's Twitter/X information.
This is Dr. David Shine, and welcome to Business Law 101.
Most Americans are aware that Special Counsel Jack Smith is attempting to prosecute former President Trump for allegedly interfering with certification of the 2020 presidential election. A recent SCOTUS ruling regarding presidential immunity appeared to throw a wrench into Smith's case. Not deterred, he has trimmed his case down somewhat, now claiming that Trump was not acting with his official authority when he took certain actions regarding the 2020 election. In the meantime, an early part of the case is still at issue. In January 2023, Smith issued a court-authorized subpoena to X, of course, formerly known as Twitter, to produce records from Trump's presidential account. However, the subpoena also forbade X from disclosing the existence of the subpoena to the former president. The dispute flared when X withheld the subject records while it challenged the non-disclosure order. X claimed that the non-disclosure order violated its First Amendment right to communicate with Trump, but the district court ruled that the order was valid and imposed, get this, a $350,000 civil contempt sanction against X. This dispute then moved to the D.C. Court of Appeals, which eventually allowed X to advise Trump of the dispute while it considered the First Amendment argument. It later ruled to uphold the district court. So X then asked SCOTUS to rule on whether social media companies can be forced to give the government a user's communications while they're prohibited from notifying the user about it. In the case of Trump, the company said that the non-disclosure order deprived him of the opportunity to assert executive privilege over the material before it was provided to special counsel. X argued that others, like doctors and lawyers, might also want the opportunity to assert privilege. However, SCOTUS just declined to hear the case, which allows the lower court ruling to stand. Frankly, this is a surprise ruling given past rulings of this court. On the other hand, since Trump was eventually told about the subpoena, the court may have deemed it moot, and the court will not consider moot cases. This is Dr. David D. Shine for Business Law 101. If you've enjoyed this episode, please subscribe on your favorite platform.